Respectfully, Your Lords, with profound respect to this honorable court, announcing appearance is P.S. Amike, lead counsel for the appellants in today's proceeding. And appearing alongside me is M.A. Adedayo. My Lords, our humble appearance is for the appellants in today's proceeding.
Yes, President. Yes.
I prepare respect to this report. I am grateful that the lead counsel of this proceeding have been with me and strengthened the future trial.
This testimony with the name of the other counsel.
B.D. Ojukaro College. Our number of prayers is for the respondents and others.
Yes, thank you. Before we go on, I want the parties to agree on the time to address the court. Since you have already filed the respective brief of the parties, the lead counsel will just have like 15 or 10 minutes to address the court, and if there's any black on points of law, we just have like 5 minutes. Are we agreed on that before we come by counsel?
My lords, it's 15 minutes for both councils or just the lead counsel manage.
Each council for each class.
Council Judge.
Are we agreed on this?
Yes.
5.
Yes, my Lord.
Thank you. Yes. Respondents council, are you agreed on that?
Yes, my lords.
Thank you. Yes. Yes, council for the applicant. The applicant.
My Lords, this appeal is slated for hearing, and with my Lord's kind permission, we will now proceed to hear the appeal. Most grateful, my Lords. My Lords, the record of appeal was entered at the registry of this honorable court on the 3rd of June, 2025. A notice of appeal against the judgment of His Lordship O.M. Okay, of the trial court delivered on the 3rd of June, 2025, dated the 3rd of June, 2025, and filed on the 3rd of June, 2025. My Lords, this contains 4 grounds of appeal. Respectfully, my Lords, the appellant's brief of argument is also dated and filed on the 3rd of June 2025. In the said brief, we have argued 4 issues from the 4 grounds of appeal. If it pleases this honorable court, we will seek the leave of this court to adopt our appellant's brief of arguments, urging this honorable court to allow this appeal and set aside the judgment of the trial court.
Yes.
Most gracious my Lord. My Lord, we hereby adopt our brief argument filed on the 3rd of June 2025. My Lord, it is our contention that the learned trial judge failed to avert his mind to the relevant position of the law before arriving at his judgment. It is thus our belief that having regard to the states of law and the authorities on this matter, the lower court fell into a grave error in reaching a decision where we believe it's perverse, and this court also discountenanced it and set aside the judgment of the lower courts. My Lord, it is in light of this circumstance that we most humbly pray this court to allow this appeal and set aside the judgment of the trial court. We are most grateful, my Lord. If there are no preliminary clarifications, my Lord, I will now proceed to elaborate on the substance and the merits of this appeal.
Yes.
Most gracious my Lord. My Lord, today's appeal is one of consequences. It's one of what will emanate when regulatory authorities are prevented from doing their statutory duties. It is not one of mere constitutional interpretation. It is one of seeking a legal and historical inquest as to why specific laws were made. Throughout the course of today's proceedings, my Lord, we will show this court that Nostra has the statutory authority to impose fines and levies, and indeed that the partial or total collapse of houses in Ogu community, which led to the displacement of over 250,000 people, 250,000 homes, and over 400,000 people, is something grave and a humanitarian crisis. And we urge this court to so hold that this goes beyond mere constitutional interpretation. My Lord, the first issue before this honorable court, is whether the trial court held in law, when it held that the complete collapse, partial collapse, or the crack of 250,000 houses in Ogu community of Bayelsa was not caused by the seismic activities of the respondent in today's proceeding, Bajumo Multinational Oil Corporation. My Lord, we submit in the affirmative that the collapse or the mass collapse of these 250,000 buildings were directly linked to the seismic activities of Bajumo Multinational Oil Corporation. And my Lord, you have also been called to determine whether the trial court erred in law by holding that the defendant did not act negligently during the course of the seismic activities. My Lord, before we proceed to the substance of this argument, it is important to clarify the key term in today's issue: seismic blast and seismic activities. My Lord, these are technical terms of which lawyers might not, in their literal knowledge, be able to provide response. And as such, we have gone to the roots and the source of people who have the kind of knowledge. And as such, my Lord, we refer you to the Department of Petroleum Resources Environmental Guidelines and Standards for the Petroleum Industry in Nigeria, which defines the seismic blast or seismic survey as a method used in oil and gas exploration where controlled explosion or vibrations are generated to identify potential oil and gas reserves. My Lord, the DPR has noted that repeated seismic blasts or seismic activities cause ground shock, vibrations, and ultimately can potentially harm many houses or buildings which are close to the oil well. My Lord, only one question is before us today. Is there a direct link between the activities of Bajumo Oil Corporation and the seismic blast that happened on the 24th of August 2024? And we answer in the affirmative. My Lord, we invite you to consider the board test which has been established in the case of Barnes vs. Chelsea Kensington Hospital, where the court held that the major determination in determining causation is to ascertain whether, if not for the activities of the claimant or the defendant, whether this damage would have happened. My Lord, the defendant in today's proceeding will seek to dispose the court and tell you that tell the court that there was a break in the chain of causation. They will rely on oil vandalization or the vandalization of pipeline. But my Lord, before we go into an inquest of the law, we would also invite you to check into the reality of Nigeria. My Lord, throughout over 50 years of oil exploration in Nigeria, oil pipeline vandalism in the Niger Delta has been a norm. It has been something reported in different news outlets from Delta to Bayelsa to Port Harcourt, numerous states in the Niger Delta. But my Lord, not in 50 years have we seen anyone that has generated such level of damage to the extent that over 250,000 houses were destroyed. My Lord, we submit that an attempt to rely on alternative causes such as vandalization without, my Lord, any evidence substantiating that claim is nothing but a futile attempt to misguide and to misdirect these honorable courts. My Lord, we also argue that the lack of alternative explanation, such as maybe an earthquake or any sort of vandalization, which in quotes is not even able to generate this harm, the lack of an alternative explanation on the side of the claimant, which makes them liable or makes their clients liable for the cause of these activities. My Lord, proceeding to the second key question is legal causation, and this has to do with the foreseeability of damage. My Lord, we recognize that seismic activities are part and parcel of the oil and gas industry, and as such, we know that it is, they would argue that it is probably not a reasonable foreseeable harm of seismic activities or surveys that houses will be destroyed or impacted. But my Lord, it has been established even in overseas township, that is the Water Mount case, that the reasonable foreseeability test is to ensure that damages are seen from the purview of the legal label. That is, whether these damages would operate or can flow from the natural occurrence of your duty. My Lord, while safety plans are perfectly fine, however, failure to adhere to industry standards and protocols by maybe environmental impact assessment and blast protocol, and all of this issue has led us to this position. My Lord, they will tell you in today's proceedings that they conducted environmental impact assessment and blast protocols. However, my Lord, again, there will be no single strand of evidence to demonstrate this. They rely on word of mouth and pray the court to hold that the word of mouth is the strongest form of evidence. We urge His Honorable Court to discountenance this.
Council, those are 2 minutes to run.
Good. Thank you very much, Your Lordship. Your Lordship, onto the second issue, which has the court has been called to determine whether NOSRA has the statutory authority to impose fines and levies. My Lord, our contention is simple: the purposive interpretation of the NOSRA Act. My Lord, we recognize that by virtue of Section 1, 5, 6, and 7 of the NOSRA Act, the scope of its authority does not explicitly cover the imposition of fines of this nature. However, my Lord, when Section 6 subsection 1A is read in alignment with Section 19, which provides that NOSRA has the authority and the duty to ensure environmental protection and remediation, my Lord, we submit that NOSRA's authority or the imposition of fine is in line of imposing this fine. My Lord, in our brief of argument filed on the 3rd of June, we attached exhibits which detailed specifically the impact. My Lord, I would like to clarify if this exhibit was served on the court.
Council, the presidency.
Okay. Most guys, my Lord. So, my Lord, it is in light of this that we submit that NOSRA has the regulatory authority to impose this fine. But my Lord, in the event that the court does not answer in the affirmative of this, we also refer this court to the provisions of Section 6 sub 2 of the Oil Pipelines Act, which vests or which states that every licensee or operator of any asset or is deemed to have the duty to ensure that every land is protected and people are protected from environmental damage. My Lord, it is in light of this and the provisions of Section 101 of the Petroleum Industry Act that says that licensee must ensure that environment are protected, that we so submit that NOSRA has the authority to impose fine. My Lord, if I may be of no further help to this honorable court, I will now defer proceedings to my co-counsel to address this honorable court on issue 2, on the last 2 issues.
You have just 4 minutes.
Respectfully, my Lord.
He's supposed to address, I said, the lead counsel. Lead counsel has 15 minutes. If you are going to reply on points of law, you will have 5 minutes thereafter. Unless you did not get the instruction from this side.
My Lord, it appears we misunderstood your intention.
Unfortunately, the law is right and the court does not speak in it. Once I'm not going to pass it. I can have so you have 2 minutes to address the 2 issues. We've already filed it, we only to stick to it.
Yes, my Lord. Most gracious, my Lord. Thank you very much for the opportunity. My Lord, seeing the limited time within which counsel must present his argument, as such, counsel will divert his energy into responding to the vain assertions of the respondent in the present case. We have read their brief of argument, my lord. As such, we refer you to their brief of argument, particularly on the first issue, on the issue of whether the host community in the present case are entitled to a 3% share, and whether that entitlement denies them the right to approach this honorable court. They have relied on the Black's Law Dictionary, which we believe to have been an insult to this honorable court, because we relied on two substantive cases that were decided by courts of repute in Nigeria, and they have defined stakeholdership to extend beyond the literal meaning contained in the Oxford Dictionary. My lord, it is on this basis that we ask this honorable court to discountenance their argument, because it is false. The submissions were based on the assumption that all communities are stakeholders within the meaning of company law. However, this is not the understanding of international law or the intent of the drafters of the Petroleum Industry Act. Even if we do accept the argument that they are stakeholders within the meaning of company law, the argument still fails, because even minority stakeholders have the right to approach the court to seek redress. How much more someone that has a legal authority, a legal right within the law, particularly within the meaning of Section 6 of 6B of the 1999 Constitution. On this issue, therefore, we ask this honorable court to discountenance the submission. On the second issue, my lord, if this court will briefly permit me to quickly address the respondent's submission.
You have 30 seconds.
Thank you, my lord. My lords, they have relied on the Nostra Act to argue that the Public Officer Protection Act do not extend to Nostra in the present case. We ask this honorable court to discountenance the submission. Our authority is Section 2 of the Nostra Act, which provides that any person in the conduct of official authority is protected. As such, any case brought outside 3 months cannot be admitted. Their case came after 3 months, my lord. As such, it cannot be admitted. Our authority also is Section 1A of the Biosar Limitation Law, which is a reflection of Section 2A of the OCOPA, my lord. My lords, they have relied on the Nostra Act, the limitation clause provided there. However, we ask this court that that provision is inapplicable in the present case, because there is a conflict of law issue here, my lords, an internal conflict of law issue. And where there is a conflict of law issue, the jurisprudence of Nigeria requires us to look for a connecting factor in determining the applicable law, especially where the matter in question is a lex situs matter, that is the place of it. The central issue here is regards a land. My lord, the custom of courts is to adopt the law that applies in that land. My lord, and based on the jurisprudence of the Supreme Court. Thank you, my lord.
You know this is not the court of first instance, so all arguments ought to have been done at the High Court, or perhaps the Magistrate Court, following the High Court. You are the court of appeal, so you should not say. It's just talking to your brief.
Thank you, my lord. Thank you so much for the opportunity, my lord. We adopt our prayers as contained in our memorial.
Thank you.
Thank you.
Yes, please.
My lords, I see the need for this court to adopt the respondent's brief of argument in response to the brief of the appellants filed on the first day of June 2025.
Yes, I will.
Most obliged, my lord. The respondents who have been present on 4 grounds filed as an appeal before this honorable court. My lords, on the ground 1, which borders on whether or not the trial court was right when it urged that the complete collapse of the building was caused by the seismic blast carried out by GMC. Furthermore, that GMC had acted negligently, my lord. My lords, the Parliament relied on the don't-fall principle to prove causation. Further relying on the court and Kevin McLean, citation being provided. The respondent faced to discuss that the principle and judicial authority accused has not in any way invalidated the judgments of the trial court, my lord. My lord, it is pertinent to note that it was stated by the respondents in the trial court that the seismic blast was not the cause of the collapse. My lord, the segment improvisation has been retained as occasion a disconnection between the respondent and the collapsed building. Thus, negligence cannot be established since there is a disconnect. My and not law. Thus, each fact should be decided in the light of its own facts, my lord. My lords, the argument claims that their argument on the concession was established through proximity in time and location, scientific possibility of self-move grasp, and absence of alternative cost, my lord. My lords, these claims are fallacious and based on football grounds, and so possibility in time and location. The scientific possibility of the sensory damage does not correlate with the empirical proving fact that was adopted by the trial court model. Free from logical assertion, the respondent shows that there is no causal link between the sensory gland and the activities of the respondents. Moving on, the evidence relying on the case of Dorothy against Tuesday, citation being provided, stated that the plaintiff respondents all ability of case to open community, further submitting the provision of section 234 of the Petroleum Industry Act 2021 and Article 24 of the Republican Charter on Human and People's Rights. My lord, the trial court did not in any way rule against this position. In fact, the trial court agreed to this position. My lords, it has been proven and adopted by the trial court that the act that caused the suffering was the act of third parties in the community and not the respondents, my lord. My lord, the assertion made by the appellants that the suffering constitutes a non-natural use of act, therefore attracting strict liability. Relying on the case of Moot against Shaw citation being provided does not apply to this case at all, as this blast is caused by a third party. Therefore, the respondent submits that the government has failed to prove the realness of causation as per negligence and negligence effect in this appeal, my lord. On the Bantu, my lord, the Bantu is based on whether or not the court was right when it else that the National High School Detention Agency had no statutory power to impose the penalty of $3.6 million on GMC, my lords. The respondent respectfully submits that the trial court decision when it held that the non-dual lacked statutory authority to impose a penalty on GMC is flawless and precise. To further elaborate on this issue, my lords, the respondents will be contrary to three sub-issues raised by the appellants. A purposive approach to statutory interpretation. My lords, it is erroneous to rely on the issue by the applicants when there are no ambiguity in section 5 and section 6 of the non-dual act. My lords, it is important to take note of the words of the CJ in subsequent case, where it was stated that but if the one of the statistics are themselves precise and non-ambiguous, then no one can be necessary that will expand this word in their natural and ordinary meaning, my lords. The provision of the law is clear. Section 5 and 6 of the non-dual act is not to pursue, this power to impose fine or levies on licenses, but to generally serve as the regulatory body for any company registered under this agency, my lord. When it is commendable that you appellant as meticulously presented the objective and function of this agency, the appellant are very carefully to establish a precise section of this statute that empowers the agency with the power to impose levy. Notably, section 5, 6, 7, 19 subsection 1, C, E, and H, relied upon by the applicant as no relevance to this issue of the imposition of levy. longer pursuing this fact, my lords. The agency has not granted hearing pursuant to section 36 of the Constitution of the Federal Republic of Nigeria. And if argued that only a court can grant hearing, it is not established that their powers are limited. Based on the foregoing, my lords, it is the potential of the respondent that Nigeria does not have the power to impose this. Rather, it is meant to seek advice from the government. This is duly stated in the legislation, my lord. We never agreed to this one to uphold the decision of the lower court in favor of the respondent. My lords, I would like to defer the proceeding of this court to my co-counsel.
Thank you. You just have 2 minutes.
As it pleases this honorable court, my lord, I will be elaborating on the third ground for appeal, my lord. My lord, the third ground for appeal is seen in memorial before the court. In order to not waste time, I will be moving forward, my lord. The respondent strongly contends that the trial court was right in holding that Ogun community cannot successfully make a claim against Kajimo Multinational Oil Company. My lord, it is strike that a stakeholder is anyone, according to the Blackstone Dictionary, which is a secondary source in the Nigerian jurisprudence. It is strike that anyone with a legal or financial or social interest in a company, such as shareholders, managers, inter alia, are seen as shareholders. My lord, I want to take the court to section 240, subsection 2 of the Petroleum Industry Act. This states and mandates that any company running oil exploration is mandated to make a contribution of 3% annually to the community, the host community, through a trust fund. My lord, it is very, very clear that the trial court did not err in law, neither did it err in fact, because there is an existing contractual agreement between the respondent and the host community, my lord. And this has actually initiated the claim, the local standing in which they have, my lord. You know, we are not denying the fact that originally they have a local standing. But we are saying that the contractual agreement that exists between them vitiates that, my lord. My lord, if the Lord can take cognizance of the memorial, it was stated, my lord, a report by Marco Trent, and it shows the amount that was actually made by the oil company, about $100 billion. 3% of $100 billion amount to about $3 billion. And if you convert that to the Nigerian currency, it becomes 4.78 billion. My lord, assuming or not considering that the seismic blast was caused by the respondent, this money is enough to take care of all the houses that have been collapsed and all the houses that have been partially collapsed. My lord, it is clear, and we want to correct the erroneous position of the appellant when they use a case that is in the memorial, my lord, Oil Pollution Watch versus NNPC. The Supreme Court stated that damages to the communities that were affected by oil spillage. The Supreme Court gave damages to the community oil spillage, my lord. This is a seismic blast that was not caused by the respondent, it was caused by the malicious act of the third party because they tampered with the installation, my lord. And this has been adulterated in the trial court, and evidence has been furnished to that effect, my lord. My lord, I would love to use the 5% that is based.
Your time is up, counsel.
Thank you very much, my lord. We have 5% in the 5 minutes, my lord, for
Not a point of law, no, not yet. You are just reacting to what you have said. You don't really you have the floor. Thank you. There's a little point of law for the appellant.
Thank you for the opportunity, my lord. My lord, on point of law, the respondents have argued that the fact that Nostra imposed the fine constitutes a violation of Section 36 of 1 of the 1999 Constitution, which guarantees the right to care. We ask this honorable court to countenance that invitation, as such interpretation is wrong. My lords, the courts have consistently recognized administrative adjudication. It is a quasi-judicial power given to administrative authorities such as the EFCC. The Nostra is just an administrative authority like EFCC, my lord. As such, in the quest of implementing the law that it has been burdened with, it imposed this the Nostra Act, my lord. My lord, as such, it's our submission that Nostra has not acted outside the bounds of the law. Council also relied extensively on Section 240, particularly on the third ground for appeal. They have argued that the profits were given to the host communities. But this is not a question of profits, my lord. It's a question of expenditure. That is the wording of Section 240 of the Petroleum Industry Act. It is not about the profits of the company. And a report by Vanguard has shown that 3 major oil companies, including Shell, Chevron, and NNPC, have only contributed $5 million to the host community fund. $5 million is a meager amount, my lord, for over 250,000 homes that have been destroyed in this community. As such, we ask this honorable to read purely the wordings of the law, which is expenditure, and which is minute in the present case. On their last argument regarding Oil Pollution Watch and NNPC, my lord, the intention of the drafters of the law must be considered. This is the position of the law in many cases. Aine versus Musa, my lord, court should read the intention of the drafters. The intention of the drafters extends beyond oil spillage, my lord. The intention is environmental protection. Anything that affects the environment comes within the bounds of the law, my lord. As such, it's our submission that the decision in Oil Pollution Board versus NNPC is valid in the present case. Because in that case, the Supreme Court granted compensation and damages, and that is what we're asking for in the present case. Seismic activity or not, it affects our environment, and that, my lord, is the appropriate interpretation of the law. My lords, based on these submissions, if this honorable court has no further question for counsel, counsel now rests the case.
Thank you very much, my lord. I would like to take rebuttal on point of my lord, on the rebuttal of point of law, it has been enunciated, my lord, by Section 6, subsection 1 of the Nostra Act, that the duties of the Nostra, they have been spelled out in that subsection, my lord, and no point of duty of Nostra shows that they have the power to levy and impose penalties and fines on certain parties. My lord, it is tried in Section 6, subsection 3 of the same Nostra Act. It was stated that the only time a penalty can be imposed is if the party is liable upon conviction, my lord. Upon conviction. And it has been enunciated in Section 6 of the Constitution of the Federal Republic of Nigeria that the arm of government that have been saddled with the duty of interpreting law and adjudicating upon cases is the judiciary. This and pursuant to Section 1, subsection 3 of the Constitution of the Federal Republic of Nigeria, it says that any law that is inconsistent with the provision of the Constitution will be held to be null and void to the extent of its inconsistency. We also want to bring the court to the section 20 of the Nostra Act, which actually states that a public officer, the only time that the Public Officer Protection Act will apply is when such person is a public officer or an employee of the agency, It does not talk about the agency as a body corporate, Therefore, it is not possible for this imposition of penalty to be statute bar, The act is ultra-biased, it is not statute bar, and if we are to rely on the case of Attorney General of Rivers State versus Attorney General of Bayelsa State, it was enunciated, that the exception to this protection of public officers is when the action that is done is ultra-biased, or when the cause of action emanates from a place that negates good faith, This is enunciated in the case of the appellant, They don't have ground, and if their actions are ultra-biased, which has been stated on point of law, and also, these have also been affirmed by the Court of Appeal in the case of yes, thank you very much, This has been enunciated in the Court of Appeal in the case of Nostra versus Moot production in Nigeria on that the NOSRA does not have any power to impose penalty or punishment on any person or party, my lord. And NOSRA is not a public officer. It is a public agency, my lord. Thank you very much, my lord.
Thank you. Thank you. You are listening to submissions of the Moot Council. The court will rise briefly and will return. Please the court will rise.
The case before us is something as decided.
Thank you. Just the ruling of the court after the constitution by my very brothers and I, through a well-argued matter and seriously contested by both parties, we hold the following position that regards the issues raised and grounds of usage. On the part of the applicants, we find 4 grounds of raised, grounds of appeal, while on the part of the applicant, 3 grounds, and on the part of the respondent, there are 4 grounds raised. And 4 issues on the respective. On the first ground 1, as raised by the applicants, we find here that on whether the complete collapse, partial collapse of crack of the houses was actually caused by the seismic blast carried out by GMOC. We actually found the experts evidence, the expert reports that refers to area of certain orders related to study. And from the experts document that was attached, we found that there was no indication of the qualification of the experts as required under the law. We looked at section 68 of the Evidence Act 2011 makes provision for expert witness. And when an expert witness is called, he's supposed to introduce himself and let the court know the qualification. Because we only have Dr. Emeka Okafor on the report, we don't know whether it's a doctor of law, or doctor of medicine, or doctor of science. It's not clearly indicated. It's important for the court to know who this expert is that is carrying the report. It's very important. That was not indicated. So it's very difficult for the court to rely on that particular document as attack. Also, it was also concerned. In law, the law is that an unsigned document is a worthless document. So there's no that being worthless for not being signed. Not related at all. All those minute details are very important to know whether it was executed by the experts. So the second ground that was raised by the applicants, whether NOSRA had the statutory power to impose a penalty or levy of $3,600,191 on GMOC. My dear brothers and I that the act itself, the enabling act. And we found that the act does not allow for dollar imposition of penalty, and there is no provision for even the levy. If you look at the contract, section 5, clearly states the objectives of that particular establishment. And in section 6, it states the amount that can be awarded in Naira, because we trade in Naira in Nigeria. So Nostra has that no right to have gone ahead to award that much, if at all that was to be awarded at all. On the third ground, which is on whether the fact that local community as the entity enjoys a share of 3% of the annual profits of the company, having become stakeholders in the activities of the company. My little brothers and I took time to look at this particular ground and scale. And having examined it, we arrived at the conclusion that the enabling law, the Petroleum Industry Act, allows parts communities, host communities, to also have some stake as the percentage share granted to the whole community. Hence, this does not, to our mind, this does not stop the community from benefiting if they suffer a loss to that extent. It is their right to be compensated for any loss as suffered. And lastly, on the ground that whether failure of GLOC to react to the penalty imposed by Nostra within 3 months rendered its action statute. This also gave us some time because we had to look again at the provisions of the law. And having examined the provisions of the law in this regard, we are constrained to instate the fact that by the enabling law, the public officers, there is a provision that in section 2A of that particular act, there's a provision that within 3 months of any particular act or action complained of, the party can make a case or sue or bring an action against that particular agency. But in this instance, we try to look at the entire brief. We're not able to pick out when, how early, or when the complaint was raised, when it was made. It's very difficult to really decipher when it was done. However, we also consider the maxim that you cannot build something on nothing. Now, where does this maxim come? Where does it come to play? If the law says that NASRA cannot in any way impose, they can only impose penalty, they cannot award compensation. If they have gone ahead to award even compensation of penalty in dollars, as we have seen, that is an error on its own. You can't give more to that. If the law says makes a provision for a fine to a particular amount, or penalty to a particular amount, or an award to a particular amount, you cannot exceed that. The law, the court does not enjoy that power to deviate from the provision, and provision of the law in this regard. So to that extent, we hold that indeed that action was practical. And we also considered the grounds as raised by the respondent as well. will reiterate the position as stated with respect to the expert witness, and also agree clearly on ground 2 that by section 6 of the Constitution of the Federal Republic of Nigeria 1999, only the courts enjoy and exercises the power to award compensation, impose fine, albeit the reference to penalty in the Nostra Act as stated in section 6 of that act. Also, the reiterate position also on ground 3 with respect to the rights of the host community, that is the whole community. And the same goes for Division 4 as raised by the respondent as well, which is on the 3 months notice, 3 months within which to react or act when the public officers goes against his powers. And in this instance, it is Nostra that appears to have acted or to have carried. So in that way, we are inclined to uphold the appeal as Thank you. Thank you. Before we step down, I want to commend the students who participated in this Moot trial. You did well, but I have observations. I'm sure my brothers will also have some observations. While you are addressing the course, consistent use of the word you. You don't address the court as you and find you behind the glass. It's not the person, it's that seat. It's an exalted seat. So you don't use it. You have to refer the lordship, the court. If you don't want to use your lordship, you use the court. Also, I also noticed while you were making your submission, that is for the applicant City Council, you wasted so much time. It's an appellate court. In appellate court, you don't need to go down the line and start. Your people is already before the court. You can just save yourself time, adopt, and then anyone that you think you really want to adopt further, just stress on that. And that's really it. So you can just do that for another time. You don't waste time. You spend so much time explaining what the sleep is all about. There's no need for that. You only say briefly because that's not the main issue. The main issue is GFOC. Are they liable to pay compensation to the tune of 3 million and something dollars? That is what whether Nostra acted or Travaris, that's the most important of this focus. And the respondents, I think both parties did that. You were citing cases of the court of appeal. When it's a decision of the same court, it only has a persuasive effect. It doesn't have any binding effect. It has no binding effect. So it's always better to make reference to the rulings or holdings of the Superior Court because we are compelled, whether you like the face of the honorable justices who held that decision or not, they are compelled to follow their duty. You can't depart from them. The departure will be tagged as judicial rascality. So you are compelled to follow that route. Audience Council, both of you, you took your time to really address the issues. You did very well in that. You are very good, very good, very good. I'm using very good because that's the way I feel about it. It was very well addressed. And I think the second council also did that for the applicant. It was the first council which took its time on that particular one. But the second council was. So next time, please, just notice and create a balance. You can time yourself. Thank God you are in the electronic age and set time for yourself. 2 minutes for this, 1 minute for this, and then that's why I was timing you. Because there are so many cases in the court and you waste time on a particular matter. Talking about a particular thing that is not of importance, the court may lose focus. So it's better to run on the main point so that the court holds on to that and gives the court that this is what they are saying and this is what they want to address. Yes, we also observed that while you were addressing the court for the appellant's counsel, you was, my lord, please say, there's none of us that is invisible. So it is my words, because there are 3 justices seated. It's an appellate court. Ordinarily, if the court is seated in its full capacity, it will be 5 justices, but for this purpose, 3 of us suffered. But both counsel, to the respondents, use my words. That's also commendable. Then for the court, anytime the court does anything, expects any court to you, the rule, professional ethics, is that you should appreciate the court. Some say it does not matter, but I want to tell you as students of law, you should adopt it. It's important. Like one of my learned brothers said once, you come to the court, you cannot appreciate that. There will be another time. Even every little court scene, because there is not all the time you remember to cross your eye or cross your teeth. But if you are conscious to the court, somehow the court may give you hints, or the court may even, if not an hint, you should know someone. And then when the court is addressing you, you have to stand unless you are allowed to sit. That's another issue. You stand, have addressed the issue of gratitude, you are not doing that. Very important. So it's important. We see a lot of things on the bench, but we want this service. Thank you.
Thank you.
We want you to be the best and come out better than perhaps many of us who have gone through now. You have the privilege of having so many days for trials. It's to expose you to what happens within the court. So unless you have anything to ask us, if not, there is. You dressed very well. Your wife's immaculate. I commend all the dressing. Unless you have anything to ask us, it must be a right.
and we've been here for the past 3 days. So I'm happy to welcome everybody to this grand finale. To kick off the program, I would like to invite some distinguished personalities to the high table. Everybody is distinguished, everybody is special, but we have some little space on the high table. So, the first person I want to invite is the greatest benefactor of Faculty of Law, Olabisi Onabanjo University. So far, the greatest ever benefactor, the most generous sponsor in the Faculty of Law's history. And that is no other person than Dr. Asekun. You are welcome, sir. Ladies and gentlemen, it's an old adage, it's a cliche now, but I would still want to use it. That beside every successful man, there is a beautifully amazing woman. And so, I want to invite the better half of Dr. Asekun to their table, Mrs. Simi Asekun. Thank you very much. Please, I want to implore us to make the applause very loud because we have Chinese television. Chinese television is a cable channel and is seen all over the world. So we want the applause to resound in every corner of the planet. Thank you very much. The next person I want to invite is the chief host of today's program. Is the head of the Faculty of Law. He is referred to as the father of jurisprudence in the faculty. He has been teaching jurisprudence for many, many decades. I want to invite Dr. Bade Olomu Akremade to their table. One of the most important events marked for today, this afternoon, is the launching of the book. And with launching comes plenty of money. Money makes the world go round. I want to invite the chief launcher of today's program, Dr. Ipaye. Please, a round of applause so that we can get millions, billions of dollars for the book launch. Dr. Babatunde Ipaye. You are most welcome, sir. Next, I want to invite a distinguished mother. She's a professor of law. From that, we normally refer to her as mother-in-law because she gave birth to many of us in the legal profession. She was once the dean of the faculty. And even though she's retired, she's not tired. She's still going strong at the age of 78. Ladies and gentlemen, please let's welcome Mama Professor Mojisola Ogumbe to the high table. Please let's give Mama a standing ovation. I think we can sing this song. Mama, oh mama, oh mama, oh. Olúwa dá màmá sí fún wa. Mama, oh mama, oh mama, oh. Mama, oh mama, oh mama, oh. Olúwa dá màmá sí fún wa. Mama, oh mama, oh mama, oh. Olúwa dá màmá sí fún wa. Thank you very much. Please let's sit down. Next, I want to invite a distinguished professor of law from one of the best universities around after OOU, and that is Babcock University. Professor Odunaike from Babcock University. You are welcome. Next, we have a a distinguished senator of the Federal Republic of Nigeria. A man that has a towering presence both physically, literally, and financially. And that is no other person than the popular Senator Legon Mustafa. Okay, he's on his way. So he went to bring his Ghana Must Go to donate to us. Next, we also have a very distinguished, honorable person, a lawyer of many years standing, a honorable member of the National Assembly, and that is no other person than Honorable Femi Ogubanwo. Okay. Next, I want to humbly invite somebody who is also very special and dear to us, Mr. Kehinde Kazeem. And the last person I will call for now, the last but not the least, is also a great man. He's a member of the Board of Trustees of the Olu and Simi Asekun Foundation. He's the representative of the foundation, a permanent member of the faculty, so to speak, Now that we have all the guests on the high table, I think we'll move on to the next program on the item, and that is the national anthem. Can we all rise? Thank you very much. The Ogun State anthem. Ìṣẹ̀yà, ìṣẹ̀yà, ọmọ Ògùn, ìṣẹ̀yà, Elédùmarè, ìṣẹ̀yà Ògùn, ìṣẹ̀yà, ọmọ Ògùn, ẹ ṣe kiri, ìṣẹ̀yà pọ̀ fún wa láti ṣe. Ọmọ rere kì í ṣàṣẹ, ọmọ Ògùn kì í ṣọ̀lẹ, ẹgbẹ̀rẹ̀ gbẹ̀rù Ọlọ́run bẹ fún wa ẹ̀tẹ̀ra ọṣẹ o. Ìṣẹ̀yà ọmọ Ògùn, ìṣẹ̀yà. Thank you very much. The OU anthem.
For us, but also to the
Thank you very much. Please, let's take our seats. Those in the technical department, this is a warning for you. By the time we're having the next program next time, make sure you get all the music together very well. We don't want all the interference and the noise. Let's have quality music. I hope that is clear. All right. The next item is the welcome address by the Dean of Law. Please let's welcome Dr. Asekun.
Distinguished guests, esteemed judges, respected faculty members, participants, we gather here today to conclude the Moot court competition. I would like to extend a warm welcome to all of you. Over the past 3 days, we have witnessed exceptional legal acumen expected at this level, rigorous research, and outstanding advocacy. I would like to take this opportunity to express heartfelt gratitude to our esteemed judges for their valuable time and expertise. Your feedback and guidance have been invaluable to our participants. To all participants, I commend your dedication, perseverance, and passion for the law. Your efforts have made this competition a success. Let us now celebrate the achievements of our winners and acknowledge the outstanding performance of all participants. That is the teams from Crescent University, University of Lagos, Asekun Akunda, Prince Abdul Abubakar University Ayinla Kogi State, Olabisi Onabanjo University, Elizabeth University Laramoki, and University of Benin. In a few moments, the individuals and teams who will walk away with the awards for this year's Moot will be announced. But by participating in the proceeding over the last 3 days, each one of you is a winner. In exchange for the considerable time and effort you have put in, you now know much about the condition precedent to the admissibility of expert evidence in litigation. May I be quick to add that I was able to hear the presentations of some of the teams. I'm impressed by the confidence and clarity of speakers I heard, and by the cogency of the arguments presented and the skillful interaction from the bench. I now know that the future is in very good hands. However, while the future is bright, much more need to be learned. Let us now celebrate the achievements of our winners, most sincerely to our benefactors, through the foundation, and congratulations to all. Thank you.
Please, another round of applause for the father of the students. Thank you very much. While the dean was presenting his address, some other distinguished personalities came in, and we would like to invite them to join the special people on the high table. I want to invite a very special friend of our benefactor, all the way from Dallas, Texas, in the United States of America. Attorney George Alibowe. Yes, I want to invite also a distinguished senator of the Federal Republic. Like I mentioned earlier, is somebody who has a powering personality, both in physical considerations, in financial considerations, and in political considerations. That is no other person than Senator Lekon Mustafa. Okay, so it's not here yet. So the next item on the agenda is the review, the book review, and we can see copies of the special book here. So this book is the first of its kind in the history of the faculty, and it is, please a round of applause. The theme of the book is expanding the frontiers of law and justice through clinical legal education, African universities and beyond. The book reviewer is Professor Dr. Sodunaike. Clinical legal education is the keystone of legal education in Nigeria and all over the world, and I'm happy to tell you that the Faculty of Law OOU practices clinical legal education. Clinical legal education is made up of two components: the law clinic and clinical teaching in the classrooms. We have a vibrant law clinic, and it is because of the activities of the law clinic that our students are well prepared for Moot competitions, human rights advocacy, street advocacy, and other activities that helps them in the law school. OU comes up with not less than 10 first-class students in the law school every year. So without taking any much time, I will continue giving more information on the clinical legal education experience of the faculty in the course of time. But now I want to invite Mr. Showobi to read the citation of the book reviewer. Please, a round of applause.
Actually, you have to remain standing while you recite. Profile of Dr. A. Odunaike, PhD, Dr. A. Odunaike, LLB, BL, LLM, PhD, OAU, is a professor of commercial and intellectual property law in the Department of Private and Commercial Law, Babcock University, where she teaches law with major focus on intellectual property law, commercial law, and family law. She served as the Vice Dean of the School of Law and Security Studies from 2011 to 2013 and 2015 to 2017 respectively. She also served as HOD, Private and Commercial Law Department from 2017 to 2023. She is currently the Provost / Dean of School of Law and Security Studies, Babcock University, and a member of Babcock University Governing Council. Under the auspices of International Board of Examination, IBE, she participated in accreditation exercise at Manila Adventist College, MAC, Philippines, and Adventist University of West Africa, Liberia. She served as consultant in establishing law faculties in some private universities in Nigeria, including Adeleke University, Caleb University, and Christopher University. She also participated in many national, regional, and international conferences, and has supervised many students both at undergraduate and postgraduate level. Professor Dr. A. Odunaike has published books, book chapters, journal articles in various national and international journals. In recognition of her contribution to knowledge, she has received a couple of lifetime achievement awards from reputable bodies and associations, including Australian Leadership Award Fellowship in 2012. She also served as a legal advisor to many organizations and to an active member of many professional bodies, including the Nigeria Bar Association, the Nigeria Association of Law Teachers, and the Nigeria Association of Adventist Lawyers. She is currently the Vice President West of Nigerian Association of Adventist Lawyers. Please have an applause for Professor.
Ladies and gentlemen, we are gradually approaching the nitty-gritty of today's business. Now, we are approaching the main business of today. Now, why is a book reviewed before the launching? I made some research and I discovered that the reasons why a book is normally reviewed before the launching is to achieve some cardinal goals. Number one, it helps to build the credibility of the book. That's number one. Number two, it helps to drive demand for the book. Number three, it positions the book for success. And number four, which is very, very critical for this afternoon's event, it helps to inspire the book launchers to increase the launch amounts in many folds. It helps to appeal to the power driving their pockets, so that, for example, if somebody wanted to donate 10 million naira to launch a copy, after listening to the review, the person will be inspired to drop 100 million naira. That is where we are going. So, the reviewer of today has a very special job. And because of that, I want us to welcome the reviewer to the podium with a standing ovation. Please, a round of applause for the reviewer, Dr. Knight.
Thank you, you may have a seat. Thank you so much. I want to start by acknowledging the management of this university, ably represented by Professor Ayodeji Johnson Oagbola, the Vice Chancellor of OOU that I met earlier on at the Moot Court, and he had to rush for the Governing Council meeting. The Deputy Vice Chancellors, University Registrar, the Dean of Faculty of Law, Dr. Badi Hakerimade, all these here present, all HODs here present, and to our benefactor, Dr. and Mrs. Olu Asekun. We are indeed very grateful. Without you, there is no event, and for this, we are grateful. To all academic or non-academic staff here present and all participants of the Olu Asekun Moot competition. Great students of OOU. Great. Are you sure you're here? Yes. That's very good. Ladies and gentlemen, I'm greatly honored for the opportunity given to me to be the reviewer of this invaluable publication, funded by Olu and Simi Asekun Foundation. By the way, Dr. Asekun turned 60 in the month of May. And I believe it is appropriate to say congratulations, sir, and to wish you many happy returns of this day. You will live long to eat the fruit of your labor. You have done so much for this faculty, and I'm able to say you are a valuable alumnus. Thank you so much. Permit me to thank the organizers of this event for inviting me to do this review. I truly appreciate this privilege that you have given unto me. The book, Expanding the Frontiers of Law and Justice Through Clinical Legal Education, African Universities and Beyond, edited by Aaron Osalau and Adijat Kubra at Kolawole, is topical and very current. Topical and very current. This topic answers 3 questions. What, how, and where? What? Expanding the frontiers of law and justice. How? Through clinical legal education. And where? In African universities and beyond. You will agree with me that the topic is all encompassing. It has both the independent variable and the dependent variable. Very good topic, very appropriate. Now the theme of clinical legal education runs through the 15 chapters. And clinical legal education is a 21st century trend in African universities, including Nigeria. So I'll be using the acronym CLE for clinical legal education to save time. So CLE has been tagged a blueprint for professional growth. Like medicine, the advocacy is that the law as a course should be taught clinically. This is because students respond positively to real experience. Why? Because reality engenders a motivation that is not possible to create with an artificial scenario. Through 15 chapters, divided into 3 parts, spread over 468 pages, the contributors offer opportunities for independent assessment of CLE in African universities, while part 1 and 2 of the book mainly deals with institutionalization, standardization, and ethical issues of clinical legal education, and the intersection of different aspects of legal training. Part 3 of the book focuses on the impact of clinical legal education on various vulnerable groups and local communities through empirical studies. The part 1 has 6 chapters. I love the division into parts. Part 2, 4 chapters, and part 3, 5 chapters. And we're going to run through briefly for you to just have an idea of the vast riches, the depth of knowledge that we have in this book. In chapter 1, the editors, Dr. Aaron Osalawo and Adijat Kubra Kolawole, they introduce CLE to the readers. And their focus is on forging empathetic and proficient lawyers in Africa. You know, sometimes you see lawyers doing their work and you wonder whether they can actually feel for their clients. And so the focus here is on the feeling of the lawyers, how you can do it in a way that will actually reveal that we are humane, we are not that hard as it seems. You know, this chapter provides a concise introduction to clinical legal education by examining the contribution of CLE to the development of empathetic future lawyers through pro bono legal services and legal aid provided for the indigent. I'm sure you are aware of pro bono legal services. What is it? It is what we use in teaching lawyers to give back to the society without necessarily charging for your fee. It's you trying to help the indigent to get justice. And that's what we do through clinical legal education. So if you want to just have a brief summary of what is in this book, if you read chapter 1, you will see that the editors, they provide a concise summary of all the chapters of the book under chapter 1. In chapter 2, Charles O. Adekoya, and I find this very interesting. I couldn't drop it as I was reading it. He wrote about confronting the questions of institutionalization of clinical legal education and standardization of law clinics in Nigeria. And this chapter identifies the gap in the institutionalization of clinical legal education, its standardization, and the challenges of implementation, as well as improper running of law clinics in a manner that deviates from its objectives. The chapter provides a conceptual clarification of CLE and then traces the evolution of CLE through the activities of NOLI, we call NOLI the Network of Universities Legal Aid Institutions in 2004. It details how CLE revolutionized legal education in Nigeria in the past 2 decades, beginning with 4 law clinics. What an humble beginning. And now we have over 56 law clinics in Nigerian universities. The chapter identifies the productive reforms that CLE has brought to legal education through projects executed by law clinics in Nigeria. And I make bold to say that the recommendation made by the author in this chapter that we should put in place enforceable benchmark as checklists that will provide clear guidance on minimum clinical practice standards for all law faculty is very, very appropriate, because that is still lacking till today. Chapter 3 by Abubakar Suleiman is a case study of the law clinic at Ahmadu Bello University. Very interesting read too. You know, the geographical spread is just too much. From the west to the north, back to the east, and on like that. In this chapter, Abubakar Suleiman highlights the lack of inclusion of ethics in the law curriculum of universities in Nigeria. We have often heard of rules of professional conduct, and the question is it binding on clinicians? Are they also to adhere strictly to the rule of professional conduct? You want to have an answer to that? Go through chapter 2. You will love it. Just read it from beginning to the end. So this chapter examines legal ethics, law clinics, and the CLE curriculum. It advocates that playing by the rules of legal ethics promotes the lawyer's legal practice. And according to Wali, in this book, the problem of the bar and the bench, they are not separable from the quality of lawyers produced by the universities. So he concludes that every bar is as good as lawyers produced by the universities, and every bench is as good as its bar. This is a very, very interesting and valuable chapter, which I recommend to everyone. Chapter 4, written by H.P. Mbago, is also on developing ethical legal practice, the role of clinical legal education in Nigeria. Like chapter 3, the focus is on legal ethics. And here, Mbago emphasized the integrity of the legal profession that hinges on the ethical conduct of its legal practitioners. This chapter analyzes the role of CLE in fostering ethical legal practice in Nigeria. The chapter examines practical strategies that can be employed through clinical legal education to instill ethical values. You want to know more about it? Please pick up chapter 4 and you will be able to understand deep culture learning. Very interesting. I'm sure some of you don't know about what deep culture learning is. Deep culture learning is knowledge of the deep culture of the legal environment where clinical legal practice operates, and it's very, very relevant to clinical legal education. According to the writer, this deep culture guides individual behavior within a cultural context, and it also helps in decision making, which is very, very apt. So I will also recommend that if you want to know more about deep learning culture, please go through chapter 5. Chapter 6, which is the last chapter in part 1 of the book, is about CLE and law clinic, written by Charity E. Unogo. In this chapter, the effect of clinical legal education was discussed. Effect of clinical legal education on access to justice and its transformative potential in addressing systemic legal challenges in African jurisdiction. In this chapter, the history of clinical legal education in Africa. Remember, we've been talking about Nigeria, and the topic of the book is expanding the frontiers of law and justice to CLE, African universities, and beyond. So it's not just in the title that we have African university. In the content of the book, we actually went through CLE in Africa and in African universities. So this particular chapter focuses on South Africa and Nigeria, and it attributes the emergence of CLE in South Africa to South African socio-political transformations in the 1970s, with the University of Cape Town being the pioneer university to adopt the legal aid clinic programs. You want to know more about this? Please pick up chapter 6. Like I said, part 2 has 4 chapters. And in these 4 chapters, the writers, they focus on legal education and legal practice. This is actually where the empirical studies is in the book. Toyin Majekodunmi, in chapter 7, gives a historical context of Nigeria's judiciary, as well as the procedural technicalities that hinder the smooth administration of justice. The author argues that CLE has played a key role in bringing to fore numerous systemic flaws in our judicial system. But of great note in this chapter is the case of State versus Shego Adefi. You need to read that case. That case, through CLE, somebody that has been put behind bars for so many years obtained his freedom. You want to know more about it? Please pick up chapter 7. Law clinic intervention, secure justice for the defendant. And this chapter clearly presents to the reader the shortcomings of Nigerian criminal justice system and establishes a strong link between legal theory, practice, and the protection of human rights. Access to justice is very important, and that's what we are teaching our students through CLE. Chapter 8 by Olu Asekun himself. Thank you, sir, for contributing this chapter to the entire book. It talks about clinical legal education and immigration law in African university, the structure, the impact, and the challenges. Very rich and very, very detailed, a valuable contribution to knowledge. In this chapter, the author examines how CLE supports immigration justice in African universities by equipping students with practical advocacy tools and offering legal aid to migrants, asylum seekers, and refugees. This chapter combines theoretical frameworks, experiential learning, access to justice, legal realism with qualitative case studies from institutions in South Africa, Uganda, Nigeria, and Kenya. 4 countries. You can see how rich that chapter is. The study examines the challenges and impact of immigration enforcement programs and skillfully incorporates a Pan-African perspective to the book, making it one of the most internationally aware chapters in the publication. This chapter explores the CLE's role in immigration justice through case studies. We have University of Pretoria Center for Human Rights, Makerere University of Refugee Law Project. In addition, the chapter not only diagnoses problems, but it also offers actionable solutions to the problem identified. Chapter 9 by Ibrahim Obadino and Babatunde Oni, riding the AI wave of risking obsolescence. Why Nigerian legal professionals must engage the future. You agree with me that artificial intelligence is the in thing. Everybody is talking about it, and in this book, you're not lagging behind the area of AI. It's also there. You want to know more? Read chapter 9. So, drawing from global trends and interdisciplinary literature, the chapter explores the implication of AI for Nigerians' legal profession. It advocates for Nigerian lawyers to embrace new skill sets such as legal technology, data ethics, and collaboration with technologies. CLE is presented as the ideal platform to equip law students with practical adaptive competencies in this fast-changing legal landscape. The author strikes a commendable balance in this chapter by advocating for increased adoption of AI while emphasizing caution in the use of legal technology. I move from there to chapter 10. Climate justice, action and litigation, opportunities for law clinics in African University by Aaron A. Salawu, one of the editors. Very good work. This chapter actually addressed the issue of climate justice. You'll be wondering, which one is climate justice again? It explores the role of law clinics in African universities in promoting climate justice and sustainable development. The study reveals major shortcomings in how climate justice is addressed in the African legal education and highlights ways in which law clinics can help to equip young people for climate advocacy. The author in this chapter presents a model for integrating climate litigation training into legal education. And I make bold to say that this is innovative and should be encouraged. The author fused theoretical legal knowledge with practical work aimed at tackling Africa's climate challenges. And this approach aligns with both the African Union's Agenda 2063 and SDG 13. positioning African universities as crucial in the continuous climate resilience journey. I commend the author for this innovative chapter. Part 3 has 5 chapters and 6 chapters. The chapter 11 by 4 authors, Ayonleye, Johnson Olusoya, Idowu Adegbite, and Adija Fukolawole. It focuses on impact of clinical teaching methods in legal education and training in Nigeria, a case study of the Faculty of Law, Olabisi Onabanjo University. In this chapter, the authors, they examine the adoption of CLE at OOU, measuring the true impact of this method of teaching. A survey of students and lecturers reveals overwhelming support for CLE as a more effective teaching strategy. Findings of this chapter suggest that clinical methods improve student advocacy, it improves writing skill, it improves research skill, and I make bold to add, it improves your ability to prefer legal opinion to issues raised. So while the empirical survey is well structured, the study's limitation to one faculty, OOU, is something that weakens its generalizability. There's something called hasty generalization. It's a fallacy. We are examining one, we can't generalize, but then it's a good starting point. Very good. The sample study, though possessing many benefits, limit the scope of the study and attempt to generalize the findings to a wider and more diverse population. But I want to say that this chapter has been recommended to one of my supervisees who is writing on legal aid and who has been struggling to really marry the two together. So it's actually a very, very rich literature which we're going to be referring to in the years to come. Chapter 12, the role of law clinics in protecting the rights of children in Nigeria by Badejobi and Aruna. This chapter links CLE with broader social justice goals, particularly child rights protection. Empirical data from interviews and surveys indicate that law clinics are impactful, but they lack resources, they lack regulatory support, and they lack specialized training for clinicians. The strength of this particular chapter lies in the use of actual field data gotten from interviews conducted with law clinicians, law clinic coordinators, and legal practitioners who are members of the International Federation of Women Lawyers. And this gives the reader a better understanding of the impact of law clinic activities on the protection of children's rights. This chapter is very, very rich, chapter 12. Now I'm on chapter 13. Remember I told you we have 15 chapters. In chapter 13, Temilade Jola Osho and Eboluwa Oshisanya, they wrote on broadening the frontiers of access to justice in indigent rural communities through clinical legal education in Nigeria. You know, access to justice actually remains a significant challenge for indigent rural communities in Nigeria, where geographic and economic barriers often hinder the protection of legal rights. So in this chapter, the writers, the authors, they explore the role of CLE in broadening access to justice in the communities examined, and the author asserts that CLE not only foster legal skills, but also directly assist marginalized individuals in navigating complex legal systems. In this vein, the author examines the effectiveness of CLE initiatives in rural Nigeria, highlighting their potential to bridge the ever-widening gap to justice, and that is to empower vulnerable population and to promote social justice. In chapter 14, strict law. I'm sure when the MC was anchoring the program, you've heard about access to justice, strict lawyering, and all the rest. Every aspect of clinical legal education is covered by this all-important book. Strict law, a vehicle for reinventing customary arbitration to multicultural Nigerian suburban communities, by Yakusak Adua. The author presents an innovative approach in addressing legal pluralism and its accompanying challenges in the Nigerian legal system. This chapter highlights how clinical legal education through the instrument of strict law can empower communities by promoting legal literacy and access to justice. The author presented street law as a tool for enhancing legal awareness and an instrument through which dispute resolutions can be improved. The author proposes the use of dramas, playlists, and other simplified methods of teaching to help communities understand how their customary practices can be merged with formal legal models to facilitate dispute resolution. This chapter rightly identifies that customary arbitration has thrived and continues to thrive in suburban communities where individuals are wary of formal channels of dispute resolution. The street law model is particularly significant because it does not dismiss indigenous practices but seeks to build on them to create a more structured institution. Very rich chapter. And finally, chapter 15. In chapter 15, Oluyemisi Bangbose, Olaoluwatofumi Bangbose, and Olutosin Olajubo, they examine law clinics navigating the period of the pandemic. And you will agree with me that we cannot but talk about the pandemic. And that gap has been filled by this chapter. They are all from the University of Ibadan Women's Law Clinic, and they're able to look at how they thrived during the COVID-19 lockdown. So the chapter examines the COVID-19 pandemic disruption of the Women's Law Clinic activities at the University of Ibadan. The author asserts that there was an alarming increase in gender-based violence and domestic abuse of women and children during the lockdown, noting that the pandemic forced the Women's Law Clinic to suspend its operation, which is a pointer to the fact that Nigeria as a country is not ready for emergencies. And that we have learned in a special way. So the chapter emphasizes the need for legal clinics to develop the mechanism for instant tech-based alternatives in the event of a pandemic so that we can ensure continuity of operations during emergencies. The chapter is of great significance because it highlights the weaknesses of the legal aid system and specifically during emergencies. In a very short time, I've been able to take you through 468 pages of the book. At this point, I want to commend the editors and the contributors for a job well done. Of great note is the simplicity of language used. Anybody can pick this book and read it and understand it. It's not in big lawyers' language. You don't blow grammar a lot, but you can read it. It's for everybody, academic, non-academic. And then I also want to commend the geographical spread of the book and the well-researched contribution to knowledge. You know, I said when I started reading, I could not put it down. I was telling her that, how do you expect me to go through 468 pages within 2 weeks? At the time, I like, why can't you just provide a summary of it? But the moment I started reading it, I just couldn't drop it. Thank you for giving me the opportunity to review this book. I truly appreciate. So in conclusion, I want to say that the book, Expanding the Frontiers of Law and Justice through Clinical Legal Education in African Universities and Beyond, has effectively affirmed the transformative potential of clinical legal education in Nigeria and in Africa. Once again, while appreciating the editors for coordinating and editing this brilliant research, I want to give sincere appreciation to our benefactor, the sponsor, Dr. and Dr. Mrs. Olu Asekun. The Yoruba will say, Olo, like that. What are you going to use to run it? It's money, and thank you for funding this. May the Lord bless you. I want to commend the creativity of each contributor and the dedication of OOU faculty and students to this book project. It is your book. Olabisi Onabanjo University is written on it. It is yours. You own it. And thank you for giving this back to us, because we will all buy copies and then put in our library. I want to say that this is a book that is not merely an evaluation of a legal education model, but it's a call for all law faculties, professionals, and other relevant stakeholders to acknowledge and promote clinical legal education as a tool for expanding the frontiers of law and justice, a tool for the transformation of the bar and the bench, and by extension, a transformation of the society. So having reviewed the 15 chapters contained in this book, I confirm that this book is a valuable contribution to knowledge in the area of clinical legal education. And I pray that this book will birth further book from the archives, from the pens of all lecturers in the Olabisi Onabanjo University. Once again, I commend this book to everyone, and I plead with you, please don't leave this place without getting a copy for yourself, and copies for your library, and copies for your friends, your students, because this is a book that when you start reading, you cannot drop it. Thank you once again, and God bless you.
Please, let's have a powerful round of applause. Please, let's have a seat. We want to thank Professor Dr. Sodunagi for the professorial review. The review was so scintillating and captivating and so delicious that I feel like taking all the books for myself. But I won't do that, so that other people will have something to read. Now there is a quotation about books that I want to share. The quotation is that a book is more than words on paper. It is a seed of change planted in the mind, growing long after the final page is turned. So what we are doing today is nothing, is something extraordinary. We are actually planting a seed of change by launching these books. Now, with special emphasis on clinical legal education, there's also a quotation. It says, in the clinic of law, books breathe life into justice, where learning meets doing and theory finds its voice in truth. In the clinic of law, books breathe life into justice, where learning meets doing and theory finds its voice in truth. That shows the importance of what we are doing today. And I also want to thank the sponsors of the book, Dr. and Mrs. Asekun, for their great impact. They've done superlatively well in sponsoring this book. Please, a round of applause for them. With their efforts and their activities, they've done so well in leaving their footsteps in the sands of time. First of all, by donating the Olu Asekun Law Resource Center to the faculty, they've immortalized their names in the history of faculties of law in Nigeria, not just in Ogun State, in Nigeria, because this is the first of its kind in Nigeria. I think that deserves a round of applause. And secondly, by sponsoring this book, they have cemented their legacy and turned their impact and influence into something of international and interjurisdictional influence. A round of applause. Thank you very much. So we are now approaching the very important aspect, the one that has to do with finance. And what, if you check the program, is item 7. It's item 7 on the program of events. And we all know how important item 7 is in any program. But before we move on, I want to recognize the presence of some distinguished personalities who came in when the book review was going on. Yes, this is the person we've been waiting for a long time. We've actually introduced him twice before he came. So everybody has been anticipating that, where is the senator? Where is the senator? So for the third time, I want to introduce the distinguished senator of the Federal Republic of Nigeria, a man who is towering physically, financially, and politically. Senator Lekan Mustapha. You are most welcome, sir. So, students, you should consider yourself privileged for seeing a senator live and direct without having to go all the way to Abuja. We all know what it costs to go to Abuja now, and you are seeing him without having to book an appointment. Also on the high table, we have another history maker in the history of the faculty. He used to be a lecturer here. He was associated with criminal law for decades until he became the first alumnus of this faculty to be elevated to the bench. He was appointed as a judge of the High Court of Ogun State. Honorable Justice A.T. Lamine. So, to our students, if not for his appointment, he will have been your criminal law lecturer and your law of evidence lecturer now. So, anytime you go to the judicial complex in Abeokuta, you can still consult him for, some lessons on criminal law and law of evidence. Thank you very much. You are welcome, sir. Okay, so now item 7. Book launchers serve different purposes. They help to build momentum for the book. They drive the early sales of the book, and they help the book stand out. That is what book launchers are for. It is not just about coming to launch it. They play a key role in sustaining and building momentum for the book. And that is why we have a fantastic list of book launchers here. A fantastic. I'm sure that. Please, can we get the ushers to go and bring Ghana Must Go bags? No problem. Cashless policy. All right. So I want to invite the chief launcher of today's event, and that is the distinguished Dr. Babatunde Ipaye. Please, a standing ovation.
Thank you, Mr. MC. Thank you. First, I'd like to recognize in absentia the Vice Chancellor, Professor Dejagbola, my very good friend. The Dean of the Faculty was our mother, the legal luminary, my mother, Professor Mrs. Okongwe. And the Lordship that was just introduced, you're welcome. I'm the chief launcher. There's a grand launcher here, my dear everyone. The chief launcher has represented the grand chief launcher. Okay, Senator Lepa Mustafa is the grand chief launcher. Just like you always send me to go and of course the co-plotters are here who will come and so you have doubled. Mr. MC had said if a book is well reviewed, okay, the launcher will put their hands in the pocket and pay 10 times what they had intended. Because I don't have capacity to pay 10 times, I will pay twice what I had intended. So by listening to you have put to rest, on a lighter note, you have put to rest the perennial debate between doctors and lawyers. Right? So there's a perennial debate between doctors and lawyers. Because anytime you see the lawyer, they say they are learned people. So the question is, who taught the learned? And because we know knowledge is not genetically transferred, right? So somebody must have taught the learned. And I understand by my training that the doctori are the teachers of the learned. Okay? And this is not confirmed by your clinical inclination to learning legal education. So now you have come back home to say you have to, as we do clinically learn law. So you have just put a confirmation to that perennial debate. I hope lawyers in this room will not debate me again. So having said that, I like to put forward first a personal launch of ₦1 million. And I will call on my dear Egbon. I won't tell him to come. So I double my boss lunch is because, of course, he doesn't want to go higher than me. He will also do $1 million. Femi, where are you? Yeah, come. Do you want to come by yourself? Femi, do you want to come by yourself or you want me to come and bring you out? Okay, Femi also do $1 million. No. Femi will do $1 million. He will do more, don't worry. He has something to do again after this moment. So Femi will do $1 million. So I've done $1 million. Who else will do $1 million? Our friend, go is 6 digits, nothing less. The minimum we can go is 6 digits. Beardo Dutola Ferrari, where are you? Ferrari. Where is it? I will do something on your behalf. Let me call him. If you don't show up, Barrister Labi. My brother is here. Bros. $500,000. We are launching. And the Bulowo Judge will not say that in the open. The chief judge will do his own name.
You won't allow you to announce it.
I know. Because it will be dangerous. Beardo Dutola, where are you? Kade Kelat. I saw Kelat now. Where is it? K. Yeah, come now. Come and take the mic. You come and support your brother. Yeah, come and support your brother. Opposition, direct you. There's only one opposition in this room. 250,000. So let's appreciate it. Omoba. Yeah, come. You are the coup plotter. Come and say it by yourself. You can't plot coup and no, you can. Odewa. $500,000. Opposition. Okay. He will announce his own. Please, I will. Where are the ushers? Ushers, where are you? Wash it and help me pass around. I want people to make their contribution. Please take a sheet of paper. People must contribute as little as. Please, if you want to join us, and sisters, do we bring papers to you? Just small. You don't have to raise money. I want to raise over 30 pen. No, I want them to write it so that there's a commitment and a name. So we'll finish in 5 minutes. Of course, I have an account number here that will be circulated. Because when you call account number out, we don't know what people will do with it. So I don't want to call anybody's account number. Okay, please, if you want to make a humble contribution donation to this, just a small sheet of paper, let people write their name, their ages. Please pass it around, please. Please just let us know if you want to participate in this launch. Please signify. Okay, thank you. Thank you, madam. Okay, let me give to opposition. Let him write so that they will not know.
Don't even talk. Just calling paper.
Have you been given the paper? Where is Beto? Okay, please give him a sheet of paper. Please help me and collect it. I want to know whether it is 6 digits. Give it to Sibarisa there. Whether 7 digits, sir. I said minimum of 6, minimum. Anthony George Anebowe from Dallas. Let me give him a sheet of paper. Give a guy a sheet of paper. It's dollars, okay? It's dollars, so you know we don't collect naira from people from Dallas. Support us in Nigeria too now. Support us in Nigeria. Just give us few dollars. You know, when we change it to naira, it's Ghana must go, we will use to carry it. Anthony Sarah Brooks. Sarah Brooks. Yeah, please, just give her so that she can give us like 5,000. Alhaji Asekun. Where's Alhaji Ebobolewa? Alhaji Latif Asekun. Help me give him a sheet of paper. Your commitment, sir. Mr. Ramon Asekun. Okay, Alhaji Asekun, thank you, 20,000 naira. Thank you so much. Tella Dedayo, thank you, 200,000. Thank you so much. Can we please appreciate them? So money is coming. Money is coming, and I'm a manageable man. Money must come in before we carry the book out. Okay, any more? Mrs. Kudirat Asekun Popola, will you give her something to write? Mr. Demola Mr. Demola Olapade. Prince Omowale Kazim, is there more here? I've not seen him. Please let me take the paper to him. I'd like to tell me Atibishe, but let me take the paper to him. So let me have what people have given. So because we need to eat 10 million before we leave here. Sir, do you want me to share this account number? My money is not good. Hello, you faculty, anytime you are raising money, you print your account number in small leaflets, small. You give to people so that they will say they don't know or they are forgotten. Look, small like this, you print it, you will circulate it. So I'm going to announce the account number now. Please note. Olu and Simi Asekun Foundation, Keystone Bank, account number, please note. 101 301 1430. I repeat it. 101301 1430. Keystone Bank, please. Please do your transfer before we leave here today. So on this note, I'd like to invite our sponsors, Dr. and Mrs. Olu Asekun, to please step forward. Mama, Professor Mr. every other members of the table, can we step forward to present this book so that publicly launch it? Please let's step forward. Our friends from Dallas, can you please join us? Our friend from Dallas, can you please join us? Please come join us, please. So, Dr. Asekun, you are going to hold it at that end. I will hold it and I will unveil the book. But I want everybody to be here. Mommy. On behalf of Olu Asekun Foundation, I have the singular honor and privilege to unveil and launch this book to the glory of God and the benefit of humanity. Amen. So can you guys come close to us? Yeah. Can you guys come close to us? Hello? Just bring it from here and come close to us. Other guests of Olu Asekun's, other guests. Thank you. Other.
So I was wondering how a doctor could be so vast in the art of raising money. So I did a little research and I discovered that apart from being a doctor, he's also an expert in project management. Please, a round of applause for the chief doctor. So, well, the normal price for the copies for students is just 20,000 naira. the price has been heavily subsidized for the students at 20,000 naira per copy. For other members of the public, it's just 50,000 naira. That is also heavily subsidized because we know that, for example, if you want to travel to Lagos now, that's how much you are going to fill the tank with. It's just 50,000 naira. So buying a book, lasts longer and it's more impactful than. So the money is just peanuts. So please, I want to urge everybody to buy at least 5 copies before leaving today. Okay, thank you very much. Now we move on to the presentation of the awards. Presentation of awards for the Moot Court competition. This is the second of its kind, the second edition. So to do the presentation of the awards, to anchor the presentation of the awards, I want to invite the chairman of the faculty ceremonies committee. She is the one who put together, she's the brains behind this event and all other ceremonies that we have in the law faculty. And then you wonder how she's able to do it, because actually she's an expert in land law, in law of equity and trust, in law of conveyancing and such. So she's not even in business law department. But when it comes to logistics and planning and putting together ceremonies, her skills are unparalleled. I want to invite Dr. A.K.A. Kolawole to anchor the presentation of awards.
Good afternoon. It's 4th of June 2025. The 2025 Asekun National Moot Court competition has been on since Monday. So that note, I want to say good afternoon, members of the high table here. I know the Vice Chancellor was there earlier, here to him. So in absentia, say good afternoon to him and to all the principal members, to the Dean of Law, and the sponsors of this occasion, also to the Chief Launcher, and our Mama, Dame Professor Ojusela Oluyemisi Ogungbe. She's as fresh as ever, sweet as the wine, roses are red, violets are blue, and so are you, ma. God bless you for us. Thank you very much. To our invited guests, I want to say welcome, and definitely this is the moment that the participants have been waiting for, and in fact the students too, everyone, you have been waiting for this. So we start with the presentation of the certificates of participation for the individual participants and also the institutional participants. And so we start with Team Crescent. Well, Team Crescent left some minutes ago, let me say about 1 hour ago. They've gotten their certificates. And so we'll go on to the next team, which is Team Abuba. And to handle the presentation to Team Abuba, I would like to call on Dr. A.O. Salam to give them their certificates of participation. There are 3, and I want to call their name to come forward. Adekunle Ajasi University has a coach called Olukoju Peace. Koju Peace. Olukayode Paul. Ajayi Temiloluwa. Where are the others? So you have a certificate of participation to show that you actually participated. Then you have the institutional certificate that you Asekun University participated in this particular. So each of you have that. The paparazzi, shall we have that? Okay. And then we are done. All right. We go on to the fathers of them all. From Prince Audu Abubakar, we have Omede Miriam Eyojo, and also Jacob Ochina. Thank you. To handle that honor, I'll call on Professor Idowu Adebite to give them the. Please let's cheer them up. From Kogi State, I served in India in 1990, and I know how far that is. We thank God for bringing me down safely. I know that when you are going back tomorrow, by the special grace of God, you meet with Johnny Mercies. Amen. And everyone. Next is Unilag, University of Lagos. The coach is Ayotunde Abiodun. The other members are Amike Precious and Adida. To handle that, I'll call on Mr. Bola Odeyale to give them the certificate of participation. All right, paparazzi. We move on to Univen, University of Benin. The coach is Dr. K.P. Odudu. I want to appreciate Dr. K.P. Odudu. It's rare for our coaches, lecturers to come with their students, and she has been with us since. And this marks a lot for me that, yes, this is a dedicated person who is also dedicated to the welfare of our works. So round of applause to Dr. K.P. Odudu. With Mofet Oluwajoda and Osawi Agbowaneten, University of Benin. To do that, I'll call on our learned jurist here, and that is beloved Honorable Justice Lamina to handle that. Thank you very much, sir. Is it punctual? But then we would like you to help us with this. Thank you very much, sir. University of Benin. Okay. Sir, yes. They have institutional, then they have individual participants. There is someone who came home from home. That has a lot of meanings. He came home from home. Here was home, he went home, and then he has come back home. And that is Coach Dr. Adeomi Taiwo, leading his team from Elisa Day University. I would like to invite Anthony George Adibowe to take a picture with his that's the alma mater of a friend of Dr. Asekun, and he has been here with them, and I know that it is a pleasure being with them today also. And here we are, repeating history. He must be feeling like he's back in Uniben of those days. Thank you, Anthony George Adibowe. I've called on Elisa Day University. Elisa Day, and definitely I know that there is someone who is close to that area and who is always shortly in that area. Our own that the Olori Oko and Olori Ebi of the Faculty of Law. I want to call on the Dean himself to present this certificate. So the person who went home from home and has come back home and his team, Coach Dr. Adewumi Tayo, and I think I mentioned the name earlier on, Oluwakemisola Olajimeji and Oluwaseun Patudiwu. And then to, last but not the least, Olabisi Onabanjo University. Coach Oluwaseun Ogunanke, who happens to also be the Chief Judge of the Official Council of the Gospel Society, and that vibrant female lawyer in the making, my learning friend, Dele Ogunanke. And also, another one popularly known as DAY. Wow. And to do that, I know we have sisters who are so close to us. We have some that are dear to us, not just in blood and not just humans, institutions also. There's a wedge of law between Bacom University and Olabisi Onabanjo University. And that's why I bring the professor here today to review a book and definitely why she came, she saw, and she conquered. I want to call on Professor Dorcas Adeleye to handle that case. Thank you very much, ma'am.
Hold on, don't move. Yes. Hello.
Yes, and we go on to look at the other awards. Those ones are just participation. Now, we know that in every competition, there is the element of sportsmanship. There ought to be, let me say, there ought to be element of sportsmanship, because some will win, some will lose. But I want to say today that there is no winner, there is no loser, because it's a moot court competition. It's a moot court competition where we have sharpened our advocacy skills, we have tested our oral skills, we have tested our written skills, and we have also been tested far. I want to commend every participant in this particular competition. Please give them a resounding round of applause. None of them is a walkover, and I can say that and say that and say that again. We started with a qualifying round, and out of 21 universities, we eliminated, I don't know max, 8 from 21, that's how many? That is 7, that's 14. So we got 8. One declined after being registered for the quarter-finalists. They got different moot facts for each of them. Especially in the last 2 days, I'm sure that most of the teams have not slept more than 1 hour because of the rigorous exercise they had to go through, the research and what have you. But then, it's a battle of wits. It's a battle of what? Not only wit, but also a battle of steel. I can say they are all made of steel. But then, the semi-finals yesterday produced the finals. At the semi-finals of yesterday, 2 teams were eliminated from going to the final stage. And so, we have 2 teams going down, but coming up today to receive their awards. I want to say that the sponsors of this program actually contemplated the fact that they wouldn't want anyone to go home without having anything with them. And so instead of having a third place match, they decided that they were going to give to the 2 semi-finalists who couldn't get to the finals awards. Not only cash prizes, but also trophies. And you can see the trophy displayed here today. This is the first time, and I'm not making mouth about it. This is the first time I'll be seeing this. I saw it first when the supplier, the vendor sent it, and I was like, wow, will there be any like this? But then, they were able to afford it. I was even telling the vendor, they shade it. But then, I talked to one of the members of the BOT of Olu and Simashi. He said, this is okay, let's go ahead. That's what Balaki Obusoya. Thank you very much. You guys see the foundation. So we have these beautiful trophies, and the 2 semi-finalists will go away with these 2 beautiful trophies that are meant for them. Who are they? We have Team Elisade. Team Elisade scored 79 in that round, but was topped by Unilag. We also have Team Uniben, scored 78. Was also topped by Orange. And so we call on the semi-finalists, the 2 semi-finalists, one by one. Let's start with Team Elisade to take the trophy alone. And to do the honors for us, we'll be calling on our own mother, the mother of the foundation itself. Because if you have a mother, and the mother has now mothers who are mothering other mothers too. So definitely we won't call her grandmother because she's a sissy. Sissy daddy, so we call on our mother to present the trophy and also the check to Team Elizabeth. The cash prize is 500,000 naira. We help Mama with this thing too. All right. Please. I want to commend Oluwakemi Sola Oladimeji of Team Elizade I had the opportunity of listening to her, and she was quite Thank you. Call on Team Uniben. Team Uniben. Coach Dr. Odudu and Fetulu Ajoda. Osawi Agonten. This come. Okay. Yes. The honors in respect of this, I want to call on, we look like we are calling only mommies, but the mommies are always there. The daddies are not always available all the time. No, that is the truth, because they are busy making money for us to spend. So that is why. Is that not true? That's true. We are always at home. We don't do anything. We just sit at home. But our daddies are always going out, looking for money for us. So I want to call on Alaja. I know I will go and ask her. I know the name. I'm sorry for that break in transmission. Yes, Alaja Oloko. She's currently the PS, that's a permanent secretary. It's like a minister in the state, so to say. And she's Alaja Oloko. I'll present this to you. Thank you very much, ma'am. I was going to say that perhaps Dr. Asekun and Mrs. Asekun should be joining the teams at each photographs. I think it's actually escaped my mind, but it's still okay. You can still call back Team Elizade to take that picture with them. Thank you very much, sir. Yes, Alaja Oloko is also a member of the council, the governing council of OU. My employer, my brother, so okay, wow. Me, Asekun, me imagine. Go deep. Thank God. Let's give them a round of applause. All the way from Great. Thank you. Congratulations. Please, mommy, don't go yet. You can still, you have to wait. Now, at the final rounds, we gave out some score sheets to people to fill for us to actually determine 2 awards. The awards are Best Advocate and also Best Memorial. I know that I gave one for the Best Memorial and this one to Sandra Brooks. And she will do the honor of giving the prize to that particular person or that institution that got the Best Memorial. The returns were made to me and I calculated and got the return that Team 0020 won the award for the Best Memorial at final round. And that's really like this has a certificate and also a plaque. the honors is my sister Sandra Brooks from Dallas, Texas. Thank you very much. And so shall we have the paparazzi, please? Yes, that other hours before any other thing. All right. So we want to go on to the one for the best advocate. I gave out some score sheets also to at least 5 persons, and they return their scores, and we find out that the best advocate goes to team 002. Whom I've researched on, who happens to have been a litigator by excellence, someone who has had the temerity and the audacity and all the cities of the world to take the whole home state of United States of America to court. In the case of Judge Anibowu and Wolf, I want to call on Attorney Judge Anibowu to do their honors as the first advocate. Shall we share them all? Dean of Law, sir, your attention is needed. We want you to come out there. Shall we share them all? Definitely, when you have occasions like this, there will be some people who are running the behind the scenes. And sometimes they also come onto the scene and you see them. But mostly, they might be behind the scenes. And that does not mean that we don't see them. That does not mean that we don't recognize the value that they have put in whatever has been entrusted to them. I usually value friendship that lasts decades, and friends that are still loyal, which is hard to find among you young ones today. The days of social media, you hear this about this person you believed. Even God Almighty did not condemn Adam and Eve in the Garden of Eden. He asked them, why did you eat the forbidden fruit? The right to fear him, as enshrined in the Constitution. But do you practice it today, my dear ones? No. You rather believe before you see. But we know that there are some people who are behind the scenes, who are always behind the scenes, and we appreciate them. And today we want to recognize one of such sterling character or personality, a friend, a brother, indeed, to the sponsors, a member of the board of trustees of the Olu and Simi Asekun Foundation, and I'm calling on no other person than Otunba Labish. We take this award and know that we mean it from the depth of our heart that we actually deserve this award. The award is presented to you, commemoration of your friendship, commemoration of your dedication. And who has to do that except another person who I'm also know that is loyal, and that is our own brother, a doctor who has become Agbowota, as he said. I'm just quoting him, sir. Doctor, sir, I quoted you. You know, there should be references. So the reference is Dr. Babatunde Ipaye, 2025, 4th of June, at 3:30 p.m. If you put that on my, we'll get it. So please do us the honors of doing that. Thank you very much. Shall we share them all? Paparazzi, are you there? Thank you very much, Otunba. When we see you, we know that you have been doing this. And we also continue to ask God to help you further. Right. Congratulations, sir. Yes, there are still 2 trophies on this table. One is bigger than the other. Who takes the bigger one? Who takes the smaller one? Wow. This is Faculty of Law, Olabisi Onabanjo University. A faculty that is known for excellence. The Harvard University of the whole world, I would say that. Again and again, we have produced several alumni who are noteworthy persons, who are persons of integrity, who are transparent in whatever means. And that is because they were bred by this faculty. And that tradition we hold dear to our hearts. And I dare say that the participants who came far and wide would have seen that in the organization of our what? Of this competition. We tried at all times to be fair and also to maintain our integrity. And that is why we can say, can beat our chest at any time to say that yes, we did what we did because it is what it is. It is what it is. And so today, we look at the finals and we have the scores returned by the judges. It was a court of appeal sitting and we had 3 justices. 2 of them arrived at a conclusion, 1 dissented, and so he didn't sign this particular paper, score sheet. He dissented. I'm sure you know the meaning of that. And so, but we have 2. 2 out of 3 is what? Majority, definitely. And so we have the scores. And the scores I have before me says, the team that is known as ONMECC, that's Olu Asekun National Moot Court Competition 2025, 020 scored 86 points, while the team known as ONMCC 25/002 scored 83 points. And so, the winner definitely will be 020, and that is the winner. We must share, no matter what, we must share, we must let them know that we are born of integrity. And so, we must share them. We are born of integrity, and we wouldn't allow anything to stay us. But before the awards are given, I would like you to stand before this room, and I will make a little bit of pontifications. Because I have to make that pontification. If I don't make it, I won't be good. I won't be good. I will see it. Okay. Wow, that's good. So definitely, We have Honorable Kubawo himself. Okay, good. All school. You know, okay. I have to make these quantifications, and that is the fact that, hello? Another great life. Wow, that's good. That's good. And I want to say that even though Mrs. Sina Shepu is not an alumnus of Unilag, she has been rooting for Unilag from day one. She's an alumnus of OAU, but she has been rooting for Unilag from day one. But I want to make some quantifications. I want to tell the members of team from Unilag that you did not win because of your arrogance or your pride, because you are outrightly proud and arrogant. I must tell you that if I were to be your mothers, I would have spoken so much words into you that you will remain fair in your life and you will always remember. You are also so assuming that the other party was willing to do you away, that this competition was not going to be fair. And your first set of words on the platform that we created for you was like, I hope the whole team is not as confused as we are, or you are going to be treating them differently. How dare you? I've said that I will not say this until today. And I will say that even if you lose, even someone else win, I will still say it. Your winning does not mean that you have the right to any pride or arrogance over anybody. Then we paired students into rooms, and then you have the audacity, the temerity of telling me that you don't want to mingle with other students. Who are you? Definitely, I must tell you that. I must tell you that. And then your dressing has always been poor from day one, especially Amike Precious. This is not a dressing befitting of someone who claims to be a learning person. And I will say that 10 times because I am a mother and I would love to correct you. And I think when you take some corrections, you'll be good. And you should not. I'm okay because I've planted my mind and I've let you go. And you also will know that at every point in time, I was also there supporting you. Even when you got confused, I led you out of it. Because it is a competition. It is not a battle to test someone's technicality or whatever. I was there to guide, and I'm sure I did well by all of you. If I didn't, you can tell the whole world. You can tell the whole world. Take this back home that you are betrayed and betrayed the OOU. That's what I'm saying. Oratory skills. The memorial was huge. Yesterday night around this time we determined the roles to be played. Not even around this time, something to 6. And by 11:46 p.m. they had already brought out a notice of appeal of 6 pages. A brief of argument of about 8 pages. If that is not credit, if that is not great work, what else is it? So you have it in you. But you see, in every human being, there must also be that element of humility. Your brilliance, your intellect will work for you, will open the door for you, not when you are arrogant. Please take that away. And I will say that no more. So I want to congratulate you heartily from the bottom of my heart, because it's a competition and we need someone who will win. And we, faculty of law, you will never manipulate anything in our favor. We will never. We will never. And I want to say it. And that is what we are alone of. All your eyes, Excellencia Humana, I give it to you. Team Unilag. Yes, I will say that it's service in all ramifications. And I want to say that it's also a double check which we can cash for 2 million naira. And now, where's the double check? All right. Alright, congratulations again and again. Please, can we join them? Please, from the high table, can we join them? Definitely. Please share them all. Yes. I don't want to tell you how money. Just let Shall we share them up more? Paparazzi, please. Yes, let's give them the honors. All right. I think that's done. Then to the team that will shine, that is shining, that will always shine. And that is Team Oru. The Eguna Tope Ibadan. The one and only faculty of law with the source. The one with the vibes. And that is Team Olabisi Onabanjo University. So let's stand up and share. You guys stand up for these giant minds that actually represented you and represented you very, very well, very decorous. You know, this is not about what made the law, it's not about legal authorities, it's also about the law. So what's the point of law is against and there's nothing you can do it, then definitely your oratory skills are coming. I want to congratulate you all. For me, you are the one that is shining. Our integrity will remain intact. Our spirit of sportsmanship is high. We are ready and willing to help everybody at every time. And I can always back that for you. So they are going away with the cash prize of 1 million naira with this trophy. The trophy. Oh, Jomunaike. Yes. And I would love to now strip myself of the total of the organizing committee and become a member of this team. So I want to say congratulations. Next year is very much around the corner. We hope to see you then, by God's grace. All right, I think we have certificates for the winner. Will you like come forward? First runner up, OOU, will you take your certificate? Thank you, everyone. I remain Dr. AKA will be given to the other teams. Team Akuba, and Team Kogi, and that is a sum of 250,000 naira each. 250,000 naira each. Team Akuba and Team Kogi, thank you for being with us. You have also been good. Thank you very much.